All right, today we are going to be discussing the topic of contingency fees explained and how lawyers get paid. Welcome to another informative segment of Live with Mitch from the law firm of Proner and Proner. I'm your host, Mel McCoy, and we sit down with the expert himself, Mr. Mitch Proner, a personal injury attorney with over 30 years of experience, here to answer your questions or any interesting topics that you might find useful in your personal injury world. And just remember, folks, if you need to contact us, all consultations are free and confidential. Call us at any time at 1-800-321-1234. Hey, how are you doing, Mitch?
Doing great, doing great. Always excited to present some information. Hopefully that anybody viewing or listening finds it beneficial. How are you doing?
I'm good. I'm good. It was a beautiful weekend. I meant to go for a ride, but I didn't. But yeah, it happens.
Good weather. Was good weather.
It was beautiful. Yeah. So let's get right into it. So one of the biggest questions people have before hiring a lawyer is, how do I pay for this? I mean, like Mitch, when it comes to someone who hires a lawyer on a contingency fee, what does that actually mean?
Any lawyer, based upon ethical rules, is supposed to have an agreement, a signed agreement, that they are representing the client. That is typically called a retainer agreement. Now, if it's a commercial transaction, like somebody's building a shopping center and they want an attorney to review the documents, that retainer agreement will typically be an amount that the individual has to pay up front. And then the attorney is supposed to keep track of the hours and deduct it from that initial payment. So let's say, for example, a criminal case. Somebody gets a DWI. They're driving while impaired, and they get arrested by the police. And they decide to get an attorney. That attorney might say, I'll do that for $3,000.
Okay.
And they have to write a check for $3,000. Now, the attorney is supposed to keep track of his hours. And if he does 3 hours at $150, then he pays himself out of that retainer agreement $450, and the rest stays in a trust account. And that's a retainer agreement. There's a specific type of an agreement that is allowed in personal injury cases that's not allowed in other types of cases. For example, a divorce, a criminal case. They're not supposed to have contingency fee agreements. An attorney's not supposed to have an agreement, oh, you only have to pay me for the divorce if I win.
Okay.
But it has been deemed ethical in personal injury cases for the attorney representing the plaintiff, that's the injured party,
Okay.
to work on a contingency fee retainer. Typically, the other attorneys representing the defense aren't contingency fee. Typically, they get paid hourly. So the attorney that represents the insurance carrier or the party that caused the injuries, they get paid hourly. But if you're the victim and you sustained injuries that you believe somebody else at fault for, and you want a personal injury attorney, the personal injury attorney can work at no charge up front. And the attorney can even lay out the expenses. And at the end, compensation comes from any settlement received. Or if the case goes to trial, from a jury verdict. If there's a judgment, then the attorney is successful at trial. Now, each state has its own rules for contingency fee agreements. For example, in Florida, they allow a 40% agreement.
Okay.
So attorneys typically will say, I have the client signed on a 40% agreement, which would mean the victim in Florida, if they hire the attorney, gets 60% and the lawyer gets 40%. In New York, the standard is a third. Attorneys in New York can't charge 40%. It's not permitted by our rules. But an attorney can charge a third. And typically the way that 1/3, 2/3 split is arranged is the attorney will sign with the client at no charge and will pay out expenses. And then at the end of the case, the attorney is entitled to a third of the recovery and reimbursement of the expenses from the client's share. Now, sometimes some attorneys will have in their agreements that they'll obtain funding from a funding company for the expenses. And the client would be responsible not just for the expenses the attorney laid out, but interest on the financing of the expenses.
Okay.
So a doctor may charge, let's say, $5,000 to write a report for the case, laying out your client's injuries to help either settle a case, or if it goes to trial, you need the doctor to exchange a report or he can't testify in court. So if anyone's ever seen a trial of a personal injury action in New York, you've seen the doctors that testify get cross-examined by the report they exchanged, because the doctor can't take the stand unless he's exchanged his report.
Mhm.
In other states, the doctors can testify without exchanging a report, but they need to be available for testimony, and they'll even have a deposition of the expert. In federal courts in New York, experts get deposed as well. They don't have to. You don't have to request that there's a deposition, but you're entitled to it. But not in state civil court in New York.
Okay.
So that $5,000 that the attorney laid out for the doctor's report and preparing for trial and trying to help settle the case, that would ultimately come out of the client's 2/3. That's a typical arrangement. Now, the attorney lays out the expenses, but it's a good idea for the client to know. For example, in my office, we don't use a finance company for our expenses. We
Right.
just get the expenses back dollar to dollar, whatever was spent.
Okay.
But other companies don't go into the bank accounts of the firm and lay out expenses. They'll use a finance company. You should know, am I paying interest on the expenses? And if so, what's the rate? And is there another way that we can handle this rather than me using a finance company? That's something a client should ask. Another good question for a client to ask is, a lot of times the attorneys, they might offer a client loan. The lending agreements also come out of the client's share.
Yeah.
And those agreements usually have high interest rates, more than you'd pay on a credit card. So I would advise that you don't enter into those funding agreements unless it's entirely necessary, and then you have your attorney sit down and go through the terms with you before you do that. But ultimately, a contingency fee retainer is a tremendous asset for the consumer.
Okay.
Because with a contingency fee retainer, you can find the best lawyer you can get, and you don't have to pay them up front. So as long as you're paying a third, you might as well get the best possible lawyer you can find.
Right.
Get an attorney who's experienced and qualified and knows your type of case. And you don't need to get somebody that says, oh, they do divorces and they do real estate closings and they do criminal and they'll also do personal injury. That's probably not the best lawyer. Now, that's a good rule of thumb. Do your homework.
Right. So I might have missed this, but so if the client doesn't win their case, I mean, do they still owe the lawyer anything?
No. The attorneys reason why contingency fee retainer is acceptable is because the attorney is burdening a lot of the risk.
Yeah. Wow. That's some really good information, Mitch. Thank you again. So, yeah.
There is one caveat.
Yeah. Yes, please.
If the case goes to trial and the attorney loses, the client might not owe the attorney any money, but the defendants could enter a judgment against the party for statutory costs.
Oh, wow. Okay.
Which are that doesn't include like the cost of defense, so it's usually tops like $3,000. But you don't want to have an accident and think you're going to get money. Then at the end you go to trial. Now instead of getting money, you got a judgment entered against you.
Yeah.
But that case goes to trial, and you should talk about that with your lawyer.
Okay. Okay.
In the United States, we don't have a loser pays system.
Got it. Okay. Well, thank you again, Mitch. That's some more insightful and great information. And there you have it, folks. You heard it from the expert himself, Mr. Mitch Proner. That'll do it for now. And thank you for taking the time to tune in, whether it's on our broadcast or podcast. We really do appreciate you taking the time to tune in. And as always, remember, you can call us 24/7 at 1-800-321-1234, where consultations are free and confidential. Also, if you haven't done it yet, please follow us on Instagram, TikTok, Facebook, and of course, YouTube. Like, share, and please subscribe so you get the latest updates. Now, before we go, Mitch, do you have anything else you want to add?
Yeah. Hopefully you don't need an attorney for an injury, but if you do, you should get the best attorney you can find, because it's going to cost you the same third. You might as well get somebody good.
There you have it. That's exactly right. Well, thanks again, Mitch, for yet another informative session with you. And thank you all for checking us out. I know I learned a lot, and I hope you did too. We'll see you next time, everyone.
Thanks, Mel. Be well.
Thank you, Mitch.